Welcome to the deep dive. This is where we take the sources, the research, and really dig in to pull out what you need to know fast.
Exactly. We sift through it so you get the core insights without all the legwork.
And today we're back in our series on the Manual of Patent Examining Procedure, the MPEP. We're navigating Chapter 1800, which is all about the Patent Cooperation Treaty, or PCT.
That's the big international system. And today we're zooming in on a specific piece, MPPP Section 1857.
Section 1857, International Publication. Sounds simple, maybe.
Well, the section itself isn't huge, but what it describes the actual publication process under the PCT is incredibly important. It's a really fundamental step.
So our mission today is to get a solid grip on this. What are the rules for publishing an international patent application? What happens because it's published? What are, practical things to know?
Right. We'll be looking at MPP 1857 itself, but also touching on the PCT articles it points to, like Article 21 and 29, and PCT rules like Rule 48, Rule 47, Rule 13 for sequences.
And other MPP sections too, right? Yeah. Like 2400 for sequence listings, 900 maybe for prior art context, 2700 for the national stage. It all connects.
It really does. Think of this publication as the moment an invention officially steps onto the world stage via the PCT system. It's a global announcement.
Okay, should be interesting. And before we jump in, a big thank you to Mike Shepard for organizing this entire audio series on the MPP.
Absolutely. And the usual disclaimer, we're using AI tools to help synthesize this, so there might be errors. This is for education, not legal advice.
Definitely. For official guidance, you always need the actual MPP, a qualified instructor, or a registered patent practitioner.
Couldn't agree more. Okay, MPP 1857. Let's start at the beginning. Who actually does the publishing?
Right, whose job is it?
That falls squarely on the International Bureau, the IB. That's part of WIPO, the World Intellectual Property Organization. PCT Article 21 makes that clear. They're the central coordinator.
Okay, the IB handles it. When does this typically happen? Is there like a set schedule?
There is a standard timeline. Generally, it happens after 18 months from the application's priority date.
Ah, the priority date. That goes back to the very first filing related to this invention, right? Could be an earlier national application, maybe a provisional?
Exactly. So that 18-month clock starts ticking from that initial filing date, counting down towards this international publication.
18 months. Seems like a specific number. Is there a reason for that?
It's really a balancing act in the PCT system. It gives the applicant time, to get their international search report, maybe a written opinion, and sort of figure out if they want to proceed into the national phase in different countries before everything's out there.
Okay, so it protects the applicant a bit.
But on the flip side, it also gets the technical info into the public domain relatively quickly, which helps innovation overall. It's faster than waiting for national grant procedures in every country.
Makes sense. A balance. But what if the applicant wants it published sooner? Are they stuck waiting 18 months?
No, not at all. They have the option. An applicant can request earlier publication. Maybe they want to establish prior art faster, or, for business reasons, they need it public.
Okay, so flexibility is built in. Now, what exactly gets published? Is it just the text of the application?
The core is the international application itself. Description, claims, drawings, the abstract. But crucially, it also includes the international search report, the ISR.
The ISR. That's the report on the prior art, right?
Yes. Or if for some reason the search authority couldn't do a proper search, which is covered by Article 17(2)(a, then the declaration explaining why gets published instead.
So you get the invention and an initial take on whether it seems new and inventive. That's pretty significant information hitting the public record together.
Absolutely. And it all has to be presented in a specific way, right? Standard format.
Definitely. The PCT regulations have detailed rules on language and formatting. It ensures consistency, so a PCT publication looks generally the same no matter where you access it.
Makes sense for a global system. Is there any way an application doesn't get published even after filing?
Yes, there's one main way mentioned. If the applicant withdraws the application before the IB finishes the technical preparations for publication.
Ah, so there's a window to pull back before it goes public through the PCT.
Exactly. It's kind of the last chance to stop the PCT publication process.
Okay. What about the content inside the application? Can the IB decide, we're not publishing this part?
They have a limited power, yes. Under Article 21(6), the IB can omit stuff they find contrary to morality or public order. Or if it's, disparaging.
Like really extreme content.
Pretty much. It's a kind of gatekeeping for offensive material.
And if they do omit something like that, is it just gone?
No. Importantly, the publication itself will note that something was omitted and why, and the full unedited application. It's still kept by the IB and available if someone requests it.
Ah, okay. So the public version might be cleaned up, but the full record exists.
Huh.
Get it.
So the application gets published, includes the ISR. How do we find it? How do we identify a specific published PCT application?
It gets its own unique number, an international publication number. Section 404 of the PCT Administrative Instructions covers this.
What does this number look like?
It always starts with WO for World Intellectual Property Organization, then the 4-digit year of publication, then a / and a 6-digit serial number.
Like the example, WO 2004123456.
Exactly like that.
And that's different from the application number itself, the one you get when you file.
Totally different. The application number tracks the file through the process. The WO number identifies the actual published document. If you hear WO number, it means the publication.
Okay, WO, year, 6 digits. Good to know. Any practical details, like when do these usually come out?
Yeah, they typically publish on Thursdays.
Thursdays. Okay, so that's the Data Watch WIPO's database if you're tracking something.
Pretty much. And once it's published by the IB, how did the national patent offices, the ones the applicant designated, get it?
The IB sends it to them routinely. That's covered by PCT Rule 47.1.
And that happens after publication, right? Not before.
Generally, yes. Rules like 93bis.1 and 47.4 basically say the transmission to designated offices doesn't happen before the actual international publication date. They get the official published version.
Okay, that makes sense. Let's switch gears slightly to a specific type of content. Sequential listings.
Yeah.
DNA, proteins, this comes up a lot in biotech. MPP 1857 mentions this and links to MP2 2400.
Right. WIPO has been publishing these online alongside the main application since 2001, I believe.
So if your application involves sequences, the listing is usually published too, and there are strict format rules for that.
Oh, yes. PCT Rule 5.2 says if you have nucleotide or amino acid sequences, you need a separate sequence listing part, and it has to follow standards to the administrative instructions, like Section 208, Annex C.
It's all about making the data standardized and searchable. And the current standard they need to use is
WIPO standard ST.26. That's the big one now. It replaced the older ST.25 standard. If you filed an international application on or after July 1st, 2022, you need to be using ST.26.
ST.26. Okay, crucial detail. What if someone messes up or doesn't provide one?
Well, if the application clearly should have one based on the disclosure and it's missing or not compliant with ST.26, the International Searching Authority say, if it's the USPTO acting as I say, they'll usually invite the applicant to fix it.
An invitation to correct.
Yes, but it typically comes with a late fee. That's under PCT Rule 13.
Okay, so a chance to fix, but it costs you. What if they still don't provide a compliant one after being asked?
Then things get serious. The ISA, or later the IPE, might limit the scope of their search or examination. They can only do so much without the proper sequence data.
Which could really hurt the application.
Absolutely. If the invention relies heavily on those sequences, a limited search or exam could, significantly weaken the application's chances down the road in the national phase.
So the clear advice for anyone filing with sequence data is
get that ST.26 compliant sequence listing ready and submit it with the international application on day one. Just avoid the whole potential mess.
Makes perfect sense. Okay, we've covered the what, when, who, how of publication plus sequences. Let's get to the legal side. What effect does this international publication actually have? PCT Article 29 is key here, right?
Yes, Article 29 addresses the legal weight. The main point is that international publication gives the application, in the countries designated, the same kind of legal protection that publishing an unexamined national application would provide in that country.
So it creates some early provisional rights against infringement, even before you enter the national phase.
In principle, yes. You get a certain level of protection stemming just from the PCT publication itself in those designated countries.
But I sense a but coming. It's not quite the same as having a granted patent, is it? Or even the same rights everywhere immediately.
Exactly. It's similar protection to a published unexamined national application, but the specifics depend heavily on each country's national law. And there are a couple of big limitations mentioned.
Okay, what are they?
First, language. If the PCT application was published in, say, English, but a designated country's official language is French,
And
then the legal effect, those provisional rights, might not actually start in France until a French translation is provided or made available there.
the language barrier can delay the legal punch. What's the other limitation?
National laws can also delay things. Even if you requested early publication, say at 12 months, Some national laws might say those provisional rights don't fully kick in until the standard 18 months have passed anyway.
Or even later.
Or maybe not until their own National Patent Office physically receives the copy of the published application from the IB. So the effective date of those rights can vary quite a bit.
Wow. So it's a global publication, but the immediate legal impact is really shaped by local rules and language. This whole act of publishing, making the invention known, it feels directly tied to the idea of prior art.
It absolutely is. While MPP 1857 focuses more on the process and the Article 29 provisional rights, the biggest consequence for the patent world is that this publication makes the invention public, globally.
And in patent terms, public means it becomes prior art.
Right. Prior art is all the existing knowledge used to judge if a new invention is actually new and non-obvious. MPP 900 talks about prior art docs on patent front pages. MPP 2100 confirms prior art under 102 can be used for 103 obviousness arguments.
So this PCT publication, chopping up at 18 months, instantly becomes part of that global prior art pool. It can be used against any later patent application anywhere.
It establishes that date certain when the world knew about this technology.
Which means if you're developing something, you have to be aware of these WO publications. Something published today could block your patent tomorrow.
Exactly. It defines the state of the art. Monitoring PCT publications is essential.
Okay. Now, we talked about the IB omitting immoral stuff. Can the applicant request things be omitted?
Yes, under PCT Rule 48.2K. But it's a totally different situation and standard.
Rule 48. How does that work? What can be omitted?
It's for sensitive or irrelevant information. But there are strict criteria. First, the info must not actually contribute to understanding the invention.
Okay, irrelevant to the tech disclosure.
Second, publishing it could harm the applicant's personal or economic interests.
Potential harm.
And third, this is crucial, there must be no overriding public interest in publishing it anyway. All three conditions have to be met.
That sounds like a high bar. Not just, I don't like this, but irrelevant, harmful, and no public need to see it.
Precisely. And here's the really important difference. If something is omitted under Rule 48 at the applicant's request.
Unlike the immoral stuff.
Right. This Rule 48 omitted content remains inaccessible from all the authorities involved, IB, ISA, IPEA, designated offices. It stays confidential within the system.
Wow, okay. That's a much stronger protection than the Article 21 omission, where the full record is still available. Rule 48 offers real confidentiality for that specific type of non-inventive, potentially harmful info.
Exactly. It's likely intended for things like maybe sensitive business details accidentally included or personal data totally unrelated to the invention, not for hiding technical secrets core to the patent.
Got it. A narrow but important tool for applicants in specific situations.
Okay, let's bring this all back home. We've gone through MPP 1857, publication timelines, content, identifiers, legal effects, sequences, omissions. Why does understanding all this international publication stuff matter so much for you, the listener?
Well, because it's the point where an international application really enters the public sphere. Knowing that 18-month timeline, knowing what's in the publication, the application plus the ISR, knowing how to find it with the WO number, that's just fundamental for tracking technology.
And understanding the legal side, those Article 29 provisional rights, even with their limits, and crucially, the fact that publication creates prior art instantly, that's vital knowledge.
Whether you're an inventor planning filings, a business tracking competitors, a student learning the system, or involved in IP valuation, understanding PCT publication helps you make sense of the global patent landscape. It tells you what's public, when, and what rights might attach.
It's knowing when the spotlight hits the invention globally.
And what that means for everyone else.
Okay, quick recap then. International Bureau publishes PCT applications, usually 18 months from priority, includes the application and the ISR. They get a unique WO number. Publication grants provisional rights under Article 29, but national laws and language can affect timing and scope. It definitely creates prior art.
Don't forget the sequence listing rules ST.26 is key, and the limited applicant option under Rule 48 to request omission of specific sensitive, non-inventive info, keeping it confidential.
Right, a lot packed into that MPP section.
It's a critical juncture in the PCT process.
So a final thought for you to consider. Think about that balance the PCT tries to achieve with this 18-month publication. It pushes technology into the public domain fairly early, which spurs innovation and creates prior art. But it also gives applicants breathing room and those limited ways to protect certain non-essential sensitive info.
It's this complex mechanism managing the worldwide flow of technical knowledge, trying to serve both inventors and the public interest. A fascinating system.
Indeed. And remember, this deep dive into MPP 1857 is just one part of our larger series covering the MP. We'll be back with more sections.
Stay tuned.
And one last time. This summary used AI tools, might have errors, is for learning only, not legal advice. Please consult the official MPP, a qualified instructor, or a patent practitioner for authoritative guidance. And thanks again to Mike Shepard for organizing this series.